Start recording. And Maria, everything's set on the live stream?
Yes.
Okay, awesome. Well, good evening, everyone. I wanted to thank you all on behalf of Pennsylvanians for Modern Courts for joining us, and thank you to Maria and the Free Library for hosting this program. And if you have the chance to fill out our pre-presentation questionnaire, it really helps our funding. It's on the screen here with QR code, and I've also put it in the chat. And for those of you who don't know, I'll provide a brief introduction to PMC. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, fairness, accessibility, and respect. For over 35 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. We aim to provide resources to make this possible for all of our residents. And so we won't be offering legal advice today, but we'll instead be kind of offering informative resources and an educational experience. And we're really, really honored to be joined today by Maureen Farrell. Maureen is the owner and principal attorney at the law offices of Maureen Farrell. Her firm concentrates on estate planning and probate legal issues. She also represents clients in the orphans court in matters where relationships and asset protection are present. Her goal is to make the court and probate process easily navigable and empower her clients in the best way possible. So we're extremely grateful for you today for joining us, Maureen, and sharing your knowledge. And we hope you all enjoyed tonight's program.
Thank you very much, Lucy. I am thrilled to be here and discuss these issues. So Lucy's just put up a table of contents. As she mentioned, I am Maureen Farrell, and my practice area is in estate planning, probate. That is when someone passes away with or without a will. And also I prepare a lot of legal papers as well. And tonight, if you have a note on your phone, or if you want to take a notepad out, just to take a few notes, because these topics are so important. And in my business and in my practice, these issues come up that I'm going to be discussing on a weekly basis. I am an attorney, so I am going to see things that you're not going to see all the time. And if you look at this slide, I'm going to give you some scenarios off the slides, but the slides are a complement to what I'm saying. And I'm sure that the slides can be given to you after. Is that correct, Lucy, that the slides can be given as well?
Yes, and our recording of this program will also be up on our YouTube, so everyone will have access to both.
Excellent, thank you. So on the slide, we talk about estate planning. And let's say that you're the client and you call my office and you say to me, I want my will done. Okay. And I start, what happens is I'll ask you some questions about why you want to get your will drafted. And on this slide, there are some different, we talk about power of attorney, limited power of attorney, financial power of attorney, healthcare power of attorney, living will, and HIPAA authorization. When you call up and you just say, I want my will done, I don't just say, okay, we're automatically going to just do your will, because a will, and if we could do the next slide, please, a will is something that you are going to use after death. Okay. It's not going to be something that is going to take effect when you're alive. So I say to clients, I say to them, okay, let's talk about some important, like tonight's discussion, important legal papers. So one important legal paper is what's called a durable financial power of attorney. And another one that we talk about is a healthcare power of attorney with a living will included, and that's called an advance directive. And then we talk about some other issues as well. Okay, but what's really important to understand is that when you call up and you're saying, I want some estate planning done, we're not just planning for you just after death. We're also talking about what you want to accomplish during life. Because some people say, okay, Maureen, they just say, I just want to spend everything. and I don't want anything left. I don't, in my will, and I just want to live my life being able to enjoy it and spend everything. And I really don't care if there's nothing left. Okay. And then there are people that say, I want my grandchildren to be able to benefit. I want to set up a trust. I want to um, change my deed to my house. I want to do some elder law planning because I may end up in a nursing home. And so I want to be able to um, be smart and judicious about how my assets are being utilized. So I just want everyone to understand this right. There's no one size fits all with what estate planning. Okay. There are different plans for different people, and there are different plans for different stages of your life. So you might come to me when you're in your 40s and you might set up one plan. And then later in your 50s, you might say, Maureen, I just want to change the plan a little bit. I have different life circumstances. I maybe have had a grandchild at this point. Maybe there's a divorce in my family. So when you talk about estate planning, it's very fluid. Okay. So it changes as your life circumstances change. But the most important thing tonight is for you to have some basic knowledge about some of these documents so you can think about, okay, at this time of my life, what should I set up? Next slide, please. Thanks. Okay. So I want to talk about this power of attorney first, okay, for finance. So if you have notes, I want everyone to think about a power of attorney and getting an attorney to draft a power of attorney for you, okay? A power of attorney is something that is used if you are incapacitated for some reason, okay, and you can't make financial decisions for yourself. So everybody says, okay, well, I have a joint checking account or something like that. So I don't need a power of attorney. A financial power of attorney is very important for this particular reason. If you become incapacitated and you cannot make decisions for yourself, okay, you're not going to be able to sign the power of attorney. So any of these documents that you're going to be drafting are going to have to be signed by you. Okay. So let's just like go through a little of the mechanics about a power of attorney. If someone comes to my office and they say, I would like my power of attorney done, okay, that person who comes to the office is called the principal in the power of attorney. Okay. And the only way that I can draft the document for the principal is if the principal has capacity to understand the document. And this makes sense, right? Because you don't want to ever have a document that you're signing that you don't understand. And so in my office, there was a slide about communication. It's really important for you and I to have like a relationship. I'm a relationship person. And for you to communicate with me why you want the power of attorney. So let's say you call me up though, and you say to me, I need a power of attorney done for my mom. And this happens probably in my office once every 2 weeks. A daughter or a son will call up and say, my mom is 98. She has dementia and I need a power of attorney. And I say to them, your mom would have to call me, okay, because she's the principal and she would have to agree to a power of attorney. And she has to understand what that document would be composed of. She has to understand the like different options under the document. And so the daughter or son will say, no, she's incapacitated. She's dementia. She can't understand it. And so when that happens, when someone cannot sign the power of attorney, then I say to the client, well, the other option is to have the court intervene for what's called the guardianship procedure. So when we talk about there's a power of attorney enables somebody to make financial decisions for you. And then there's a guardianship procedure. And there really isn't a middle type of ground. Okay. So if you don't have a power of attorney can cost, let's say, for just getting that done, a couple of hours of work for an attorney. A guardianship procedure and a court proceeding probably is going to run about $5,000. Okay. And the court is going to intervene on what you have to do as a guardian. So when you become guardian, you're going to have to put in court papers, an annual report, an inventory, a budget. You're going to have to ask to sell a property. You are going to be subject to the court for every decision that you're making as a guardian. So if you have a power of attorney, okay, and you draft the document while you have capacity, and then if you become incapacitated where you can't understand things, you're going to choose somebody in your power of attorney called an agent to make decisions for you. And I strongly suggest when you choose an agent that you choose someone who is very trustworthy. Because in my practice, I also have litigation where someone has chosen an agent. I had this issue like where the account is literally cleaned out. Okay, so the principal chooses an agent, the principal becomes incapacitated, and the agent now has power of attorney and starts taking money out of the account. And sometimes the agents feel like that money is their money. So you have to be very careful and on who you choose as your agent. An agent is a fiduciary. So an agent has the ability to make certain decisions for you. Okay, so the most important thing is who are you going to choose as an agent? And you should also choose somebody as a backup agent because sometimes you might choose somebody to make decisions for you, and that person, for whatever reason, might have moved out of the country or just might not be around. And so it's really important to say, okay, I need an agent to make decisions if I'm incapacitated, and I also need a backup agent as well. Okay, so let's just go over what a power of attorney can do for you. So on the front cover of the power of attorney, each state has different forms. Okay, so Pennsylvania has a form. On the front of it, it'll be in bold. And on the front of the power of attorney, it'll say that your agent can make financial decisions for you and even sell your house. Okay, so you have to understand that under a general durable financial power of attorney, an agent can sell your house. So this can be positive for you though, because let's say you're incapacitated and you have to go into the nursing home or you move into your daughter's house or son's house, or for some reason you just move to it, you want to move to a different, like an apartment, and you're having trouble focusing or not understanding, your agent should be able to do that. But if it's the wrong person and you don't trust them and you have reservations, I don't want my agent to do that, then that person you should not choose. Okay. So this document can be very helpful to you, but it also can be very harmful to you if it's in the wrong hands. So it's really important when you come into my office that we customize the document. So we decide, you and I together, what powers your agent would have. Okay. And the powers that your agent are going to have, your agent's going to have are based on what your reasonable expectations would be. So let's say I have a client, okay, that comes in and they say, I give to my grandchildren every year $500. Okay. And that's what they've done for many years. So I would say to them, okay, we can put in the power of attorney that you like to give gifts to your grandchildren. And we're going to communicate with your agent. We're going to have them come in and talk. And we're going to tell the agent, we want you to continue. If something happens to me, I want you to continue to give the $500 gifts. Okay. And gifts are in the power of attorney. And you want to be very careful because some of the power of attorneys say you can give a gift, even my entire estate. So if that provision is in there, you can even give a gift of my entire estate and you don't understand it and you sign that, your agent can give away gifts, okay, of your entire estate. So it's so important to understand this document and read it and go through it with your attorney, okay? And there are 8 powers in this document that you have to sign off on, okay? And those are powers about, like, you can give away your life insurance policy. Like, do you want your power of attorney to be able to change the beneficiary on your life insurance policy? And so you have to talk to me about it, or whoever you choose to be your attorney, about, do I want my agent to be able to do that if I'm incapacitated? And then there are about, I think it's about 30 or 40 general powers that are included, like being able to access a safe deposit box, being able, as I mentioned, to sell your home, being able to take out a loan. There's also, like, let's say you fell in some kind of like personal injury type of lawsuit, your power of attorney could continue the lawsuit for you. Okay. But remember what I said on the other side, if you don't have one, okay, you're not going to be able to get one once you're incapacitated. Okay. And you're going to have to proceed with a guardianship type of court proceeding. So it's really important to think about these documents in advance. Next slide, please. Okay, and we were talking about some of these issues that come up. I also want, in terms of like passwords and things like that, that's another thing that you want to make sure that your agent knows to your passwords. And there are many passwords that change, and some of my clients say, well, they're on my phone or whatever. But I always recommend that your fiduciaries, whoever you pick, has, like I have in my office, like a list of just what they are. Because sometimes your power of attorney might want to shut down. Like, this is like your, let's say you're incapacitated, you have like some kind of account, email or whatever, and you don't want it running, your power of attorney can shut it down if they know your password. And the same thing happens after death, where you might have a lot of accounts, okay, that, let's say Facebook or LinkedIn, or you have blog posts and things like that. You really want your executor to have the list of passwords, because it's difficult. Many of these sites are very difficult to shut down. And there are different terms of service. I mean, there's a lot of like messy type of situations that occur. So you want to make sure that whoever you choose for your agent and your executor, that these documents that you create, you want to make sure that they have the document, okay, and that they understand, your agent too understands, like, these are my responsibilities. An agent, also under power of attorney, has to keep track of the transactions that they do. Okay, so you're going to decide, when you draft this with your attorney, you're going to say, okay, well, how often, should the person, if I ask to see the, like, let's say I'm incapacitated, but I want to see some of the transactions they've made, you can say, well, I want every 6 months they should have to show me the transactions, or every 3 months. And this is really important, because once you become an agent, right, and you're making transactions, you're taking money out of the principal's account, let's say to pay a bill, you want to make sure that you list that on, like, a spreadsheet or wherever way you list it. Because if you lose that receipt, okay, those little receipts sometimes, I mean, just take a picture. Don't just keep a file of receipts. They get like old and torn. You can't read them. Okay, so negligence is no excuse. So if you start paying bills, and you're an honorable agent, okay, and you've paid bills and you've done a good job, you then, okay, if one of the beneficiaries under the will says, I want to see these transactions you've made, because I'm supposed to get something under mom's will, and mom has now died, and you took out money for X, and you want to be able to say, as the agent, here's everything that I did, okay? And if you can't say, here's everything I did, this is when you start getting sued, okay? And I mean, I've had people call up, and they've become power of attorney for their grandmother. I've had daughters as power of attorney for grandmothers, and they were using grandma's money to pay for their IVF. I mean, this is the kind of things that happen. So would grandma expect you to be using her money to pay for your IVF? I mean, so this is how, or change deeds in our house to put you and your husband on. I mean, things occur all the time. So make sure you put an agent down. I would not put co-agents. I would have one agent. And if that agent is not working out, you're going to remove the agent and then you're going to put someone else, or you're going to revoke the power of attorney. But you really, in this case, you really want your attorney who helps you in your corner. Okay. You need the team in your corner to make sure, like if someone's an agent, I make them come to the office and talk to me about what they're going to do. Okay. Because of these issues with essentially stealing people's money is what occurs. Next slide. All right. And so this power of attorney is like, sometimes I think it's just we can do a brief talk on this. It's like if you're going to go sell your home or something like that, and you're going to have somebody, maybe your real estate agent sometimes acts as your limited power of attorney, or sometimes your attorney will act as limited. So this is just for limited type of situations. The one we talked about before was a general one. And I just want to make a point. Remember, power of attorney for finance and power of attorney for health, two documents that you're going to use when you're alive. Okay, those are during life. Your last will and testament will take over after you die. So when you're power of attorney, right, you're able to pay mom's bills or do things for mom. But once mom dies, okay, you can't start using that power of attorney after mom died. Okay, you get in a lot of trouble if you knew mom died and you start taking money out. Okay, let me just say that again. If you knew the person died and you kept on taking money out. Okay, so those documents during life. So when I talked about an estate plan, I'm talking about planning during life and then planning post death. So it's something that you got to keep in mind. And I also want you to understand in Pennsylvania, they're very strict about when you come into your attorney's office and you have to sign the power of attorney. I'm very strict about making sure you sign it in front of me and making sure the notary sees you sign it. Okay. So this is an important thing, to have the notary there and the notary and then two witnesses to make sure it's you signing it. And the witnesses cannot be like, they shouldn't be like, the agent cannot be the witness. I sometimes will act as the witness, but we want to make sure that we have witnesses that saw you sign. We want to make sure that the notary saw you sign, because we want to make sure all these things are correct. Because when you take this power of attorney to use it and you go to a bank, sometimes a bank will question power of attorney, and that's for another night. And they'll say, well, what is this? You know, we don't maybe we don't believe that this is actually a good faith power of attorney. So if you have this prepared properly, okay, by an attorney that knows what they're doing, you're not going to have that kind of problem when you go to the bank. Sometimes the banks or brokerages have their own forms. But the problem, you know, you could fill out that form, but the problem is that form going to be good everywhere else? It's just their own form. So, you know, I recommend just getting a general one to have. And then the other type, when we talk about a general power of attorney, that is one, as soon as you signed it, even if you're not incapacitated, when you sign it in my office, that can take effect. Okay. And there's also another power of attorney called the springing power of attorney. That means it doesn't take effect until you're actually incapacitated. So there's two different types of power of attorney. We can discuss which one you want, but the general one will take effect right away, so your agent can do things for you right away. Springing is only if you're incapacitated. The issue that I have with the springing power of attorney is, let's say you say to me, Maureen, I don't want someone to run around with a power of attorney, and I'm concerned that they're going to do something, you know, right there, that's concerning. But okay, so I only want the person to use it if I'm incapacitated and I want a springing. So I said, okay, you want a springing power of attorney, but the issue is that proving you're incapacitated. So let's say you become incapacitated, and now the power of attorney needs to make decisions, do things right away, like maybe pay a medical bill, whatever they need to do right away. And in order in Pennsylvania to prove you're incapacitated, we have to have two doctors say that you are. So what happens is, with a springing power of attorney, you're going to have to get two doctors to examine you and whatever test they need to do. So it sometimes it's not always as effective if you need things done quickly. So these are all things to discuss. Should I have one just that I have and I don't have my agent sign it until I need it used, or should I have one only that takes effect only if I'm incapacitated? But if I have that power of attorney, this springing one, I have to have a doctor, two doctors, and incapacity is not necessarily the easiest thing to prove. Okay, like dementia, sometimes it's early stages is very different than the later stages. And so maybe you might have a situation where the doctor says, I don't believe they're totally incapacitated. I don't believe that, so um, all of these things are very important. That this is a big thing tonight, is to plan in advance, because when people call up my office, it's scurrying. It's a lot of times like, uh-oh, this is going on. And it's tough because it's trying to make a decision when you're under a lot of stress. And so when you're making decisions under stress, you get your heart starts racing, you're calling an attorney you don't know, and this kind of stuff. Your decisions aren't going to be as good as they would be if you were thinking this through. Like the poor daughter or son that calls me up and wants it for their mom, and they're desperate, and it's just a very difficult situation. Um, so tonight, just plan is the most important thing. Next slide, please. Oh, if anyone has any questions, feel free to interject. Um, so we talked about this, about the durable versus springing and taking effect immediately. And I just want to say, this issue about the agent, I always meet with the principal. We'll sit down and talk together, and we'll discuss who you're going to pick as the agent. And then later we can have the agent come in and I'll go over what they need to do. The agent also has to sign something that says they're going to act for the principal's benefit, they're going to act loyally, things like that. So we go over all this together and decide later who your agent's going to be. Next slide. All right. So the notice form is on the cover of the power of attorney, and it's something that I will read with my clients. Okay. So notice means that it's in bold, and it's just like telling you that your house could be sold. It's telling you that your power of attorney has to use the reasonable expectations of what you would expect, and you have to communicate those. So the notice, don't let that even scare you at all, because it's just the front of the power of attorney in bold, and we read it together, and then you're going to sign it at the bottom. Okay, and date it. Next slide, please. Okay. These are more getting into the mechanics of the power of attorney, which we can get into a little bit more detail another night, because I do want to, but it's just that, this sort of acknowledgement that you understand it and things like that. Okay. So I want to make sure, because we have a little shorter time, that I get to this. So a healthcare power of attorney is a power of attorney that gives your agent. So we're talking about an agent again, but before we were talking about finance, and now we're talking about health. Forms used to be combined. Okay, there used to be a health and finance form combined. And so when you would go to the bank, you would have your healthcare, like organ donation, on that form. It no longer is true. So when you speak to your lawyer, you're going to have two different forms. You're going to have a form for the financial power of attorney and a form for your healthcare power of attorney. So now your healthcare power of attorney is where you're going to pick out someone, the same thing, an agent and a backup agent, okay, to make decisions for you in case of healthcare emergencies. So this person is going to have to, let's say they have to make a decision about your care if you're in a state where you can't speak. Okay, so think about the person in your life. This is a traumatic experience. If I said to somebody, you're gonna have to make decisions when let's say I'm in a state where I can't speak. It's very traumatic for the family. It's very traumatic and difficult to make decisions. So that your healthcare power of attorney, you want to think about who is the person in my life that will be able to make these kind of decisions for me. Okay. And that person that you choose, I mean, they can consult with other people, but ultimately, if you're in a state where you can't speak, the hospital is going to ask the healthcare agent what to do. Okay. So you don't ever want to be in a situation where you don't have this document. Because if you don't have this document, what is going to happen? You're going to have people, your poor family is scurrying around trying to figure out what to do. So the most important thing tonight is communication about these issues, because these issues, like I said, they come up in my practice all the time, and they're not going to come up for you all the time. But I'm sure there are folks on this call that this has happened to, and trying to make these decisions when you're trying to figure out what your mom, your dad would have wanted is very difficult. So thinking about, okay, who's going to be the agent? And so your agent is going to be able to access your medical records. So whoever you decide is the agent, there are a series of 6 different things or 7 that they can do. But the hospital is very clear about this. So if you put as your agent your daughter, let's say, and your daughter comes in and wants to access your medical records, that's fine. But let's say somebody else comes in and wants them. They're going to only be able to access them. Your daughter's only going to be able to access the medical records, and other people are not. So this is the other thing, it's a protection for you. You don't want people to just be able to access your medical records. Okay. So this is another reason to put an agent and then a backup. And you're going to put in the document, you're going to put how to reach contact information for your agent. Like we put in my office, like primary contact. We put different, because you want your agents to be able, for the hospital or doctor, whoever it is, okay, how do I contact so that these people, and you want to have a backup just in case for some reason, cell phones do die, and sometimes service is bad. You want to have that backup. Okay. But you want to have a conversation with your healthcare agent, and you want to have a candid conversation if you can. I know it's difficult, but you want to talk about what decisions you would want in case you can't make them. So in the advanced directive is picking out your healthcare agent in the first few pages, okay? And the next part is talking about what do I want if I am in a state of, and there's a different term now, but vegetative state, okay? Or if I have some kind of terminal illness and I know I'm terminal, and what do I want in that case? Okay. So this is called the living will portion. So the first portion is choosing your agent, contact information. Your agent can get medical records, choosing an alternate. Okay. And then the next part of the document is the living will part. I want everyone to understand this. The living will portion takes place when you are in states like a vegetative state, okay, or you've decided, though, you're in a terminal state, you're not going back. The living will is states like that. The living will is not for like if you broke your leg or something like that, okay? These are conditions they're very severe, is when your living will is going to take effect. So in the living will portion, there in Pennsylvania, there are like 9 things, I believe. Okay. And the living will is more about not what you do want if you're in that state, but what you don't want. And I want everyone to think about, okay, if I am in, let's just say, a vegetative state where there's no brain activity, everybody should think about what is my quality of life? Like, what do I enjoy? And I put some resources at the end of this that you can look through their workbooks. at the very end of the talk. And I think they're really helpful to just like get the conversation going. But if I'm a vegetable, my quality of life is like I like Sundays with my grandchild. I like to walk in the woods. I like to do these things, whatever. So think about, what measures do I want? Okay. And so your healthcare agent, if you're in this state, your healthcare agent is going to be looking at your living will to determine what you said you didn't want if you're in that state. Okay. And then some of my clients are saying, if I'm medically burdensome, like if I'm going to be, my relatives are going to come, my family's going to come and see me on a daily basis or visit me in this state. What do I want? So it's thinking about, like, everybody on this call is an individual, and there's no right or wrong decision. You have to make the best decision for you. Like, I have clients all over, they want all different things. So you, in the living will portion, you're going to figure out, okay, if I'm in this state where there's no two doctors in Pennsylvania have to determine where I don't have any brain activity, like I'm just not responsive. Maybe my heart is beating, but my brain is not functioning properly. And there are gray areas. I'm not a doctor. Just kind of want everyone to know it's best to talk to your doctor about these issues too. Okay, so do I want, first off, do I want pain medication? Okay, so if I'm in the state, do I want my healthcare agent to give pain medication? I don't know whether you feel pain or not, but that's one of the I do or do not want. And you're gonna have to check off. And I have my client's initial. I do or do not want cardiac resuscitation. Like, if my heart stopped, do I want, like, my heart to whatever they do for cardiac resuscitation? Do I want those measures? Do I want to have a tube put down my throat? Okay, do I want that? Do I want, now this is only if you're in these states of terminal illness or vegetative. Do I want kidney dialysis? Do I want blood transfusion? And it'll, on the form, it says I do or do not. Okay. So you're going to check off which ones you do and you do not. The most difficult one is that there is for hydration and nutrition. Um, and that one's very tough because of what happens if there's not hydration and nutrition. So that one is personal preference. And I highly suggest that you talk to your physician about this. And I also think once you have this document witnessed and notarized, the document is good for that state. Okay, so let's say we're in Pennsylvania, but what I always recommend to my clients is make sure you can make copies of this and bring it with you. So, like, if you're traveling, um, like if you like to go on a cruise or wherever you like to go, if you're, going to, I don't know, wherever, Aruba, whatever, have it with you because most of the time, the state where you are, wherever you are, wants to see what you have, even if it's from another state, okay, or another country or whatever. So I highly recommend that you give this to your doctor in advance. You give people these documents, okay, because you don't want to draft them and just throw them in a drawer, okay, because then what's the purpose? You want to be able to utilize them. And I always recommend to, once you draft documents like your will, your power of attorney for health, your power of attorney for finance, come up with a safe spot. I mean, you don't know how many times I have clients that call up and say, I drafted a will or I drafted a trust and I lost it. I don't know where it is. Okay, so you're gonna then incur expense. So either find some kind of safe that there are fireproof ones, but I have clients that they've melted, which is not good. But and I think some banks have safe deposit boxes. But make copies of these documents. The last will and testament has to be the original when it's presented, but the other two documents, the power of attorney documents, they can be copies. So it's important to have copies. You can also have them on your phone. Okay, you can, like, I send my clients like a digital copy so that agents that you picked, make sure they have copies, okay? Because they're the ones that are going to make this decision for you. So don't just throw them once you have them. Don't just throw them in a drawer and you forget. Just especially the healthcare document. Okay, that one you really want to give to your doctor. Um, and the healthcare document, the document also asks, are you an organ donor? Okay, so things like that, you're gonna put whether you want organ donation. I know you have it on, you may have it on your license. And also my document, we put goals. Some people want like a priest there, some people want like certain things. And so if you get this drafted with somebody like an attorney, or you can write these things. But the more that your agent knows in advance of what you want, it's just that is better for everyone. It's better for the hospital. It's better for all your relatives, and it's these things are for you ultimately, though. Okay, they're for you to feel. And I know the topics are not easy. Like these are tough topics that I'm talking about tonight. But I feel like these kind of like talks and things like that, we have to understand this because we don't understand it. It's just you're going to go into the hospital and it's that stress again. It's the race. I have people call up the day before their surgery and they want these documents. And I mean, it's almost impossible to get an attorney to draft something and get witnesses and discuss them the day before surgery. So I'm just for you. I just want you to think about, okay, let me just do these before. And so I'm not so stressed out about them. Next slide, please.
And just to give you an idea of time, we have about 3 minutes
Okay.
left.
Yeah. That's
Sorry to
why I
rush
like
you.
skip. That's right. I skipped the acknowledgement and all that because I was like, oh my God. Um, so I think we went through this stuff, organ donation, things like that. And we can get, anybody who wants to give me a call, I'm happy to talk to them for a few minutes too about this. We can do the next slide. I don't know how many we have left here. All right, so this is yes, and this is like where the living will, just sort of an example of what I was talking about, and the checking off and things like that. You can do the next one. So right, so HIPAA, so that's what I was talking about too. I think I covered a lot of this, but just a little bit different than the slides are showing. Yeah, so what we're showing here in the HIPAA is the form that you're going to be reading this. So we go through this in my office. But I do think medical records is really important. And I do think the healthcare agent, I have had healthcare agents call me up when it's an emergency and they're having difficulty doing what mom wanted. So we talk through that. Because some healthcare agents, like they don't want to actually do what mom wanted. So and the hospital is listening to the agent. So this goes back to my original theme, like make sure, okay, who am I going to have as my agent? Are they going to do what I want? Because I mean, what is the point of drafting these documents if your agent's not going to do what you wanted in the first place? Next slide. Yeah, these are just good examples of what it would look like. All right, and that's me. So in the last few minutes, I just want to point out so everybody, your plan is individualized. Everybody's plan is different. But these documents, the power of attorney for finance, they're and the power of attorney for health, they're inexpensive in terms of the comparison. Like as I said, for a guardianship, 5,000 versus 500, okay, to draft, and the peace of mind that you get. So just make sure do these things for you. Like tonight, this is all about you and giving you information. Because and then educate others too, if you've gotten it done, just the importance of having these documents drafted. And remember, these documents are personal to you, they're all customized, there's no one size fits all. And I'm happy to talk to anybody who calls. We'll have a short free consultation. So, and I want to thank both the Free Library and PMC. I love the Free Library, by the way. They're amazing. And their Kindle and all this that I get all these books, they're incredible. And PMC does such great work. So thank you both for having me tonight.
Thank you so much, Maureen. We really appreciate your time.
Oh, thank you. Were there any questions from anyone tonight? We have a quiet audience tonight.
Yeah, I don't think anything came in through the chat.
I see something on there, but I'm not sure whether it's just me or is that
I
just
think that
the.
was my initial message of a
Oh, okay.
pre-presentation
Okay, great.
questionnaire.
All right. Am I hitting the time right?
Yeah, that was perfect. Thank you so much.
Thank you so much. It was nice seeing you guys again.
Great to
I
see you.
I'm not being, am I still on record?
I can stop that.